Last week, the Speaker of Parliament ordered members who have boycotted plenary sessions to be excluded from any activity related to the House.
If members have decided to be out of the House, then that means they should also not be in the committees, because a committee is an extension of the House. They should not, and this one goes to the clerk.
On Monday morning, some of the usual activities, including committee proceedings, started with low attendance by the respective members.
Can you introduce yourself?
The Committee on Rules, Privileges and Discipline was the most affected. The committee had convened to investigate allegations that the Mityana Municipality MP Francis Zaake used defamatory statements against fellow MP Julie Kinyamatama while the accused was in Rakai district. Lawyer Erias Lukwago, who represents MP Zaake, was in place to defend his client.
My client is not before this committee, and Chair, we are making a prayer that you be pleased to suspend these proceedings on grounds that our client cannot access the precincts of Parliament.
Lukwago expressed disappointment over the committee for not adhering to the directives of the Speaker and convened the session, requesting that his client Zaake appears.
And whatever the Speaker makes on record on the floor of Parliament, the Speaker's directive is captured on the Hansard. So it is there. It's not about to hearsay too.
Whoever is here is not here illegally or was not hijacked. Letters were written to us, meaning that those letters take precedent over the Speaker's communication, because the clerk to Parliament.
She has not been blocked. Nobody is being blocked. Zaake is appearing before this committee as a witness, though he is still a member of Parliament.
Lawyer Lukwago says the Speaker's directives are a subject of Constitutional Court description.
We are sitting down with the Honorable Zaake and other members of Parliament to challenge this decision of the Speaker, which we consider to be atravailous because she has no powers.
The Deputy Chairperson of the Rules Committee, Father Charles Onen, vowed to continue with the proceedings, accusing Lawyer Lukwago of playing to the gallery.
It is for the good of your client. It is for the good of this committee, for the good of the Parliament. I hope you wish Parliament well and this committee.
Most obliged, Chair.
Yes. So tomorrow, same time, we expect you to be here with your work.
But the complainant said she will not be here tomorrow.
We have not received, any formal communication.
Meanwhile, the Minister for Justice and Constitutional Affairs, Norbert Mao, has defended the move to increase justices of the Supreme Court and Court of Appeal. Government plans to increase the number of Supreme Court justices from 11 to 21 and Court of Appeal justices from 15 to 55. According to Minister Mao, this will address case backlog. Minister Mao appeared before the Legal and Parliamentary Affairs Committee, led by MP Fox Odoi.
This justification, which we wrote, states that the increase of the number of justices of the Court of Appeal will result in the increase of the number of justices of the Court of Appeal at regional level. Election petitions will be handled by the regional courts of appeal, thus reducing the cost of justice.
Mao says the increment will also allow some cases not to be affected by emergencies like sickness by some justices.
There are other issues which I hope we will discuss in camera.
Yes. I know. We have also restricted ourselves.
We will request you, Mr. Chairman, to allow us to engage in camera on the issues afflicting the judiciary, including some of the frustrations that I'm sure as members of Parliament you have received regarding certain individual justices.
Last week, some legislators attributed the case backlog to poor productivity and case management by justices.
And we are alive to the age of some of our justices, which has disabled the courts from constituting panels. We are also alive to the distances that our justices of appeal have to travel because the court is not regionalized due to the limited number.
The Judicial Amendment Bill 2023 was tabled last week for first reading, and the Speaker referred it to the Committee on Legal and Parliamentary Affairs.
This is part
Daniel Mugoya, UBC News.
of the comprehensive solution